Okay, so good morning, everyone. We are delighted to see so many people here. A panel on Chevron on a Saturday morning when it's beautiful outside. So thank you guys for not making us talk to ourselves in this room. My name is Kate Shaw. I teach at Cardozo Law School in New York City, and I have the privilege of moderating this morning's panel. The title is Deference in Doubt, the Future of Chevron and the Administrative State. So the topic is the pretty deep skepticism we have seen in the last couple of years emanating from both some scholarly and some judicial quarters about Chevron, and here we'll just use that as general shorthand for judicial deference to the interpretations of administrative agencies. So the panel is definitely about some very technical debates, sort of technical and doctrinal, but the debates are about some quite profound questions regarding institutional roles, institutional competence, accountability, independence, essentially where institutionally the power to make certain sorts of decisions ought to reside. Of course, Congress gets to make those decisions in the first instance, but it does not always speak with perfect clarity, and so that really only starts the conversation. So big critical institutional and separation of powers questions. And there has just been some interesting both debate and realignment about the right answers to those questions in recent years. So I'm just going to briefly introduce and then turn it over to our panelists, but a couple of brief housekeeping notes first. First, a request that you silence your phones. A second, a reminder that the session has been approved for CLE credits, so be sure to grab one of those CLE forms if you would like, and the CLE materials are available online. And if you tweet, and please do tweet. The handle is ACS at ACS Law, and the convention hashtag is hashtag ACS 2016. So please use those. Okay, so I will briefly introduce our panel. You have lengthier bios in the program, and I'll introduce in the order in which folks will speak. So first up, we have Chris Walker, who teaches at Ohio State. He's a scholar of administrative law, and he also spent time at the Department of Justice before becoming an academic, including defending federal agencies, so he brings that perspective. Next, we'll have Boris Burstein, who's a partner at Skadden, who before that spent time in a few different roles in government, including, importantly, running the Office of Information and Regulatory Affairs, or OIRA, as the acting administrator. We'll then hear from Allison Zeeb, who's the general counsel and the head of litigation of a public citizen, who actively litigates and thinks hard about the sorts of cases and issues that we are discussing today. And then finally, Sabeel Rahman, who teaches at Brooklyn Law School, whose work focuses on financial regulation. They are having fun in that panel. All right, we'll have to crank up. We'll have to crank up the entertainment value in here. I promise we will try. So financial regulation, sort of informed by questions of democratic theory, among other things. So we have perspectives from litigation. Both from within and outside of government, from regulators, from the academy, and folks who've spent time in all of the above roles. Quickly before we start, just can I get a show of hands, just for our own edification? We're not going to call on anyone, but of how many law students are in the room? I think it'll be helpful. Okay, so a good number. So this is not, particularly if you've just finished your first year of law school, these cases and some of this terminology is not going to be familiar to you. So we will do our best, and I'll try to kind of monitor if I feel like we need to lay more groundwork. But thank you for that. So with that, I'll turn it over to Chris to start us off.
Well, this is so great, and thanks so much, Kate, for organizing this. This is gonna be a fun hour and a half for us ad law geeks, and for the rest of you, this will be a good idea to see whether you are an ad law geek by the end of this. So Congress, the Republicans in Congress in April introduced an act called the Separation of Powers Restoration Act, and it's a very simple statute. It amends 706 of the Administrative Procedure Act to instruct courts to review de novo all agency statutory interpretations and rules. And in other words, it's an attempt by the Republicans in Congress to get rid of Chevron deference. This idea, this doctrine that's been formally around since the Chevron decision over 3 decades ago that says that courts have to defer to a reasonable interpretation offered by an agency of an ambiguous statute that the agency administers. Now, Chevron deference is this places the power with the agency instead of the court to be the primary interpreter of statutes that agencies administer. There are a number of different reasons why we have Chevron deference, and the court has told us over the years that it's this idea that when Congress delegates by leaving ambiguities, that we want agencies to fill those holes and not courts. Some people say it's based on comparative agency expertise, that agencies are the experts in their regulatory areas. In fact, they help draft the legislation that ultimately they interpret. Others base it on political accountability, the idea that the president generally has some more power definitely over the agencies than over courts. And so if we're worried about someone making policy, agencies are in a better position to do that. Other rationales for Chevron deference are the idea that it allows for more uniform federal administrative law, because you have one agency saying what the law is across all of the nation, instead of a patchwork of various circuit courts interpreting what the law means. So those are kind of the main rationales for Chevron deference. There are maybe some more nefarious rationales as well that we might get into, that Congress is, it's costly to legislate, and it's easier to leave ambiguities. It's easier to take the credit when agencies do well and blame the agencies when they do poorly. And so there's some other rationales for Chevron that have been developed in the political science literature along those lines. Now, this legislation, the Separation of Powers Restoration Act, it didn't appear out of thin air. It has been a concerted effort by the justices on the Supreme Court and legal academics and policy wonks on the right, generally, have been agitating for either a narrowing or just a complete termination of Chevron deference. And so you might have heard of Philip Hamburger's book, Is Administrative Law Unlawful? Or Adrian Vermeule's really awesome titled response, No. That was a great read. Over the last 5 years, the justices on the right have started to express concern with Chevron deference. I kind of trace it back first to the Chief Justice in his dissent in the city of Arlington. The case is about whether agencies can define their own scope of authority, and he didn't think that the bright line approach should work. And I just want to quote one part. He says, and the whole opinion has language like this: the framers could hardly have envisioned today's vast and varied federal bureaucracy and the authority administrative agencies now hold over our economic, social, and political activities. The chief, I think, expanded on his dissent in the King v. Burwell decision last year. This was the one challenging the exchanges provision that the federal government put forward in the Affordable Care Act. In that case, he said, we're not going to defer it all to the IRS. We don't think this is the type of question that the IRS has expertise to handle or that Congress would have delegated. And then last year, at the very end of the term as well, we had Justice Thomas in Michigan versus EPA in his concurrence. This was the do you have to consider costs when deciding whether to regulate under the Clean Air Act. He actually went forward and expressed serious constitutional concerns about Chevron deference, that it transfers power from the judiciary to agencies in a way that violates both Article 1 and Article 3 of the U.S. Constitution. And you see that same language if you go read the sponsor statements and the press releases around the Separation of Powers Restoration Act. You'll see that a lot of the same themes from Phil Hamburger's book and from these opinions, sometimes direct quotes, are what's influencing the Republicans in Congress to get rid of Chevron deference. So that's kind of the new skeptics of Chevron that have emerged. I want to just spend a couple minutes. Do I have a couple minutes?
Yeah, definitely.
So one of the responses you might get is Chevron deference doesn't matter. Oh, I got 1 minute. I'll get through it. It doesn't matter. Judges don't use doctrine to make decisions. They figure out the answer they want to have, and they just go there and they reach it. So it doesn't matter what type of deference standard you apply. There's a great empirical study by Bill Eskridge and Lauren Baer at the Supreme Court that demonstrates, I think, pretty well that, at least based on their data, that Chevron doesn't matter at the Supreme Court. Or in other words, whether they apply Chevron or some lesser standard, it doesn't matter. I'm not in that camp. I think Chevron matters a ton. Maybe not at the Supreme Court, but at the lower courts, it definitely matters. Kent Barnett at Georgia and I just finished a study of 1,500 Chevron decisions over 11 years in the courts of appeals. And courts of appeals apply Chevron 75% of the time. And when they apply Chevron, the agency wins 77% of the time. When they don't apply Chevron, the agency wins 53% of the time. So there's a pretty big difference. There's some methodological warts on the study, but it's hard to overcome the idea that there's about a 25 percentage point difference when Chevron applies. And then lastly, it matters at the agency level. I spent a year surveying and interviewing agency rule drafters a couple of years ago. And the agency rule drafters, I asked them about 20 or so interpretive canons. What do you use when you interpret statutes and draft regulations? And Chevron was the big winner. 90% of the rule drafters said they use Chevron when they interpret statutes and draft regulations. And when I asked more questions about it, and the evidence wasn't quite as strong, but when I asked more questions, well, how do you use it? And they said, vast majority said, we think about judicial review standards when we're drafting regulations. And 2 and 5 said that they agree or strongly agree that they're more aggressive in their interpretive efforts if they are confident Chevron will apply. And then other 2 and 5 somewhat agreed with that. And so I do think it matters at the circuit court level, and it definitely matters at the agency level, that what level of deference applies is going to affect how aggressive agencies are in fulfilling their statutory mandate.
Great, thank you. Okay, Boris?
Good morning. I'm going to focus really very specifically on one of the cases that Chris just mentioned, King v. Burwell. And I'm going to try to make the case to you that, putting aside whether it makes a difference for policy reasons, on legal grounds, this case really seems to throw the Chevron doctrine into some uncertainty. I'm going to try to do that using a tool that those of you who are students and those of you who are practitioners might be somewhat familiar with, a cite check. A source site. Right? And if any of you are sitting next to a law professor, you should feel free to explain what that is. I'm friends with a lot of law professors, but I'll never be invited back. So let me start by telling you what King v. Burwell was about, with just a little bit more detail than Chris. As you know, the Affordable Care Act establishes a regulatory scheme whereby insurance providers cannot deny insurance coverage on the basis of pre-existing medical conditions. Now, that kind of system can only work well if people don't wait until they get sick to get insurance, thus the proverbial individual mandate. Everybody has to get insurance, and in order to ensure that, in order to make certain that folks can afford insurance, tax credits are provided. And those are based in part on income. Now, then there are these things called exchanges, which are basically marketplaces in which people can go and buy insurance, sometimes using their tax credits. And the states are authorized to establish these exchanges state by state. And if a state decides not to establish an exchange, then federal government will come in and establish one for it. The provision governing the qualifications for tax credits indicates that a person to get a tax credit has to purchase a qualifying insurance coverage on an exchange established by the state. And IRS, shortly after the statute was enacted, has promulgated a regulation saying when it says, established by the state, it could be established by the state if it chose to establish an exchange, or by the federal government if the state chose to withdraw and the federal government came in and for that state established an exchange. That seems sort of sensible. But a group of plaintiffs, and who will just put aside how they have standing, it's a little complicated, but they do have standing, have brought a challenge, a kind of a textual challenge, saying the law says established by the state, and state means the state. So if the federal government established it, then it's not a state, and I guess they don't qualify for tax credits. As you know, a number of cases like this have bubbled up through the courts. The Supreme Court eventually, by a 6-3 vote, ruled that the better reading of the statute is that established by the state means by the state, as in the state of Virginia, or by the federal government in place of the state of Virginia. But oddly, the court the court just read the statute. It didn't defer to the interpretation of the statute given promulgated by the Internal Revenue Service through regulation. And it did so in one paragraph. So it's going to be a short source site for us. It cites two cases, so it'll be pretty elementary. And basically that paragraph stands for two propositions. It says, first, well, this seems like too important an issue for us to give deference to an agency. And anyway, the IRS is the wrong agency. So let's try to test that proposition. So for the proposition that this is too important, this is just not a deference kind of issue. The Supreme Court's, this is an opinion by Chief Justice Roberts, cited a case from the prior term called Utility Air Regulatory Group. Now, the issue in that case was whether the permitting requirements for pollution emitters under the Clean Air Act being promulgated back in the 70s, should include greenhouse gas permitting. And the court basically reasoned, well, look, nobody thought in the 1970s that the permitting would cover greenhouse gases. And well, I will just read to you the sort of the money quote from that decision. An agency that claims to discover in a long extant statute, here being the Clean Air Act, the unheralded power to regulate, the unheralded power, that's a key phrase here, a significant portion of the economy, well, then that's not an appropriate opportunity for deference. And the court cited in another decision, will be diligent source citers, Brown versus Williamson versus FDA, where the Supreme Court concluded that the Food, Drug, and Cosmetics Act, enacted in the first half of the 20th century, didn't contemplate tobacco regulation. Again, long extant statute, unheralded power. So we have a test. Let's try to apply it to the Affordable Care Act. So long extant statute. Well, that sort of works for the FDA example, beginning of the 20th century. Nobody thought, people didn't really quite understand the health implications of tobacco. So long extant statute, unheralded power. Clean Air Act, it's conceivable that Congress wasn't very familiar with the greenhouse gas and climate implications when promulgated the Clean Air Act. But what about the Affordable Care Act? Well, the long extant statute, well, that doesn't quite seem to work, right? Affordable Care Act promulgated in 2010, regulation promulgated in 2012. That's pretty fast by the way the wheels of administration move. Unheralded power. So the question here is, well, if the Congress had afforded the government the authority to issue tax credits, I guess somebody would have to decide who qualifies for those tax credits, right? And that's not an unheralded, that's an unheralded power. We've got to get some new heralds, right? It's pretty predictable. And then I'll touch briefly on the second point, is IRS the right agency? So for that, the court cites a decision from a few years ago, Gonzalez v. Oregon, where in reaction to the physician-assisted suicide state statute in Oregon, the Justice Department in the prior administration had determined that prescribing lethal doses of drugs to terminally ill patients is not legitimate medical practice. And the Supreme Court concluded, well, determining what legitimate medical practice is not really the business of the Department of Justice. Well, that makes sense. So let's try to apply this syllogism here. So determining what the tax credits are is not really the legitimate business of the Internal Revenue Service. Well, that doesn't really quite work, does it? The court tried to take a quick evasive maneuver here by saying, well, it's not, maybe not tax credit, but a health insurance policy. So I did the obvious thing. I took the phrase tax credit and I did the word search just of this decision. That phrase seems to come up about 100 times in the decision. Then I did a word search for health insurance policy, and that comes up once in the sentence that talks about IRS being the wrong agency. So the maneuver, while evasive, is arguably not terribly persuasive. And of course, everything IRS does can be characterized as economic policy, business policy, science policy, or in this case, health insurance policy. It doesn't really seem to be a distinction that works. So maybe I will stop there and. Well, I guess I'll just leave you with the thought. So that's the sources. We've done a source site, and that maybe explains why some of us think, well, what is happening to Chevron? Are we a little bit at sea?
Okay, and so we'll leave the question there, but we will, in the exchange and Q&A, we'll definitely sort of do some digging into what the upshots of all that might be. First, though, let's hear from Allison. Thanks.
So as we think about Chevron, and maybe some of us worry a little bit about efforts to undermine it, I just wanted to take a minute to reflect that Chevron is not a consistent friend of either party or of progressives any more than conservatives. Courts, and I have in mind primarily the DC Circuit, have relied on Chevron to reject challenges to weak auto safety regulations, to weak clinical testing rules, and to a range of 1980s rollbacks of environmental protections, which I think is why Justice Scalia originally liked Chevron. In 2003 decision, the DC Circuit deferred to a new agency definition that contradicted 20 years of prior agency statements as to the meaning of a statutory term. And when the court agreed that prior reading was the most natural one, and as a result left sensitive areas of land such as national parks and historic sites unprotected from subsidence caused by coal mining. In a current case that we're working on, although the court hasn't ruled on it, it's Public Citizen versus FEC, the commission is seeking deference to a denial of a citizen petition that was not denied based on any reasoned decision-making, but because the commission deadlocked, and so by default denied the petition. So they're claiming deference to the denial there. When the Supreme Court issued its decision in Meade, I think a lot of people see that as sort of as a big deal, but I saw it as reminding the agencies and the lower courts of a sensible approach to Chevron.
Wait, will you give a little bit more context for those unfamiliar with Meade?
So I will.
Thank you.
Meade specifies that courts should defer where Congress delegated rulemaking to the agency and the agency's action was taken in furtherance of that delegated authority. So under Meade, if the statute is clear, there's no basis for Chevron deference, which shouldn't be that remarkable. That's Chevron step one, and you don't get to step two if step one answers the question. And if the statute is ambiguous, but the ambiguity is not one that Congress intended the agency to fill, there would also be no deference. The idea is that deference doesn't apply when the court is faced with an issue of pure statutory interpretation. And that's not really new. It wasn't really new when Meade was issued in 2001. A number of cases had recognized it. According to the Chief Justice, Burwell falls into this category. There was no basis for thinking that the IRS was acting within its delegated authority, well, that its interpretation was of the word exchanges was something that Congress wanted the IRS to fill. So it's sort of a too big to defer case, but it's also sort of in line with a number of cases because the application of Chevron by the courts over the 30 years, it's inconsistent. They use it when they like it, and they don't mention it when they don't want to, or when the statute's clear. If a court is going to decide a case at Chevron step one, there's no need to talk about Chevron or to mention Chevron step two. So at this point, you might think and mistakenly think that I'm an ally of the congressional Republicans who want to do away with Chevron. That's not the case. The latest effort, as Chris mentioned, is the Separation of Powers Restoration Act. That's H.R. 4768. Committee held a hearing on it Thursday. The idea behind the title, the Separation of Powers Restoration Act, is that Chevron is inconsistent with the separation of powers because the the executive branch is getting too much authority to make and interpret law. So in the name of preserving congressional power, really, the bill proposes to shift authority to the courts, which is sort of an odd thing right there. So this change is really simple. Where the APA says that the reviewing court shall decide all relevant questions of law, the bill would say shall decide de novo all questions of law. And the theory is that this will do away with Chevron. I think the bill is both misguided and likely ineffectual. So first, until I'm told I have to stop, the courts under the APA have the authority to interpret statutes, and it's in the exercise of that authority that they have developed Chevron. But they're applying de novo review. When I litigate an APA case, even if it's a Chevron case, I'll start by saying that this standard of review is de novo. The first step in that de novo review is to see if you can discern congressional intent using the plain language, the purpose, the context, and the legislative history, unless you're in the Supreme Court. And the second step is, if you still don't have an answer, is to see whether the agency's interpretation is reasonable. The question of whether it's reasonable, if you get to step 2, is also decided de novo. You don't defer to the agency as to the question of whether the agency's interpretation is reasonable. So I don't know that this bill makes a difference. Second, I'm not sure that it would, where was I? I'm not sure what the option would be. In Chevron itself, Justice Stevens wrote, I'll finish my sentence. They didn't have an answer. He said, we can't figure out what this means. So there has to be something to do at that point. And my third point, if I had time to say it, was, I think the courts, if they stop saying deference, they'll just say that they're going to apply an arbitrary and capricious review. That happened to me in one case, which we briefed as a Chevron case, DOJ briefed as a Chevron case, and the DC Circuit said, no, that's not right. The question is whether it's arbitrary and capricious. And then I lost in that way.
Okay, well, thanks. Sabeel, please go ahead.
Great. So I think I want to zoom out a little bit and give some of the broader context, kind of circling back to where Kate started us off on what's at stake for progressives, right, in all of this. And part of this has to do with institutional responsibilities, and part of this has to do with the broader history of the relationship between progressivism and the regulatory state writ large. So I think Allison's comments really point to this core tension for progressives, right? Which is, on the one hand, we need the regulatory state to do a lot of the things, public policy-wise, right, that we want to do. But on the other hand, there's this kind of worry, right, persistent problem of whether we call it regulatory capture or regulatory failure, like the ways in which administrative agencies might fall short, right, either because they're under-resourced, they have under-capacity, or they're unduly influenced by different groups. And so the battles over Chevron, the doctrinal battles over Chevron are sort of playing out with all of this in the background. And some of the shifting, the realignments of who's in favor of Chevron and who's not over the decades, that's kind of what's going on in the background. So, you know, if we think about from this kind of broader perspective, right? I think what these debates about Chevron and the SOPA Act right now kind of point to, I think, is that for progressives and progressive lawyers especially, we need a way of thinking through what is our theory of the administrative state, right? How, on the one hand, how can we preserve the administrative state from the kinds of judicial interventions that make it really difficult for agencies to do the things that it seems that they're clearly Congress has intended them to do, or the democratic process has intended them to do, but still take seriously some of the concerns about regulatory failure. And what I want to throw on the table to add to this discussion is the way in which the internal structure of the administrative process itself might be an area for lawyers and practitioners to think about, right, in addition to the doctrinal areas. So I'll just mention a couple points quickly, and we can get into them in the discussion. So if we think about the problem of regulatory failure, there's a couple of angles to it. It's often not the literal sort of story of, you know, quid pro quo capture or lobbying or influence. It's to the extent that it's a problem, it's often more subtle, right? Agencies have, to the extent there might be more reliant on outside actors for information, for research, to the extent that regulators share a kind of common social background with the industries that they are regulating. And progressives historically have gone through waves of different ways of trying to tackle this problem. So, you know, one set of responses has to do with presidential administration and oversight of the regulatory state itself. So through executive orders, through regulatory review at OIRA and elsewhere, maybe Boris might talk a little bit about if it comes up more. So that's one angle. Another angle that was attempted in a previous moment in the doctrine was to try to use courts to ensure greater interest representation and participation of a wider range of stakeholders through revised doctrines of standing, revised doctrines of due process, and that sort of faded away after a while. And I think that we rightly have a concern about having courts meddling too much with the administrative process because that can go either way, right? It's really indeterminate. So the main point I want to kind of direct us towards is, from a practice standpoint, how can we structure the internal workings of the agencies themselves? So if we take an example like the Consumer Financial Protection Bureau, sort of the latest agency to be created from whole cloth. And one of the things I think is really interesting about the CFPB is the ways in which this idea of preserving the public interest ethos of the agency is baked into the design and staffing and operation of the agency itself. So few ways in this that this plays out. One is that the CFPB has an independent source of funding. Its funding comes from the Fed, not from Congress. So that already gives it a much more stable basis of resources and insulates it to some degree from the kinds of attacks or concerns that we're all talking about on the panel. The second is internally, the CFPB has a number of offices that are dedicated to, on the one hand, research functions, and on the other hand, various forms of stakeholder engagement, right? Proactively reaching out to the kinds of communities that are affected by the regulation, but may not have the resources or sophistication to lobby the agency in the way that the financial industry might. And then the third is on the personnel side, and partly just because of the time in which the CFPB was created, a lot of the staff in the CFPB have a kind of a greater degree of sophistication about the use of, for example, technology, social media, online platforms, and also have roots in a wider range of constituencies that are interested in consumer finance and consumer protection. So all of this, I think, sort of gives the CFPB a distinctive flavor, a distinctive organizational dynamic, which which I think is helpful for the broader lesson for the themes of this panel, is that this navigating this tension between protecting the agency from undue influence of the courts or of conservative backlash, but also ensuring that the agency does, in fact, work in a way that serves the public interest. And I'll leave it there.
Okay, great. So thanks, everybody, for these opening remarks. So, my first question, I think, sort of touches on, so Chris started by saying, sort of making explicit something that I guess I didn't in my opening statement, which is that the most of the attacks we're seeing on Chevron are coming from the right? So that is just sort of kind of a background fact. And so I want to kind of take us a little bit into this question of sort of how the role of kind of the ideological valence of and sort of the upshot of some of the attacks we're seeing on Chevron. And Allison, so Chris sort of lays that, just sort of offers that as a background fact. Allison, I think, I gathered sort of nicely challenges part of the premise of this panel, which sort of seems to take as implicit that progressives, there's an attack on Chevron coming from the right, and that progressives ought to be mounting sort of a full-throated defense of Chevron. Right? And Allison sort of reminds us that that it is not always the case that Chevron helps progressive causes. So that's and then. I take maybe I'll start with asking Sibyl. You talked about sort of internal constraints and sort of challenges from a slightly different perspective, but I guess as that so I think that there's in some sense that the shift that there's a conservative attack on. You can sort of say the kind of powers of the administrative state right now feels potentially attributable to just raw politics, right? So any doctrine that gives more power to agencies feels problematic when the executive branch is controlled by the other party. So if you have conservative judges skeptical about Chevron when there's a Democrat in the White House, sort of you can see that, and certainly I think that you had more progressive skepticism about Chevron in the 1980s when the doctrine was first sort of kind of articulated and then kind of getting its footing. But so is it just that reductive and simple, right? And I guess I'd be interested to hear from all of you that it is just this kind of when you are out of power, Chevron is problematic. And if so, why are we sort of seeing these challenges now? And I mean, I think they've been building over the last few years, but it is not just, it is a little odd that you'd be seeing them now as opposed to more like 2009. So that I think challenges a little bit the really simple political explanation. And then I guess this question, and maybe this was implicit in what Sibyl was saying and I missed it, but is it ultimately the case that Chevron only helps or hurts depending on where you stand, or is there something that it is fundamentally inherently kind of conservative and anti-regulatory, this type of skepticism, in that although regulations can be conservative or progressive, as a general matter, giving more latitude to administrative agencies is a progressive value because it will just have government regulating more of our life, which is, generally speaking, on kind of current divides, more of a progressive value. So maybe I'll throw that somewhat sprawling question out and let anybody who would like take it up.
Right. So I'll just say a couple things quickly. I mean, I think the politics part of it is obviously very real, right, as a driver for why we're in this moment. I think that's definitely true. But I do think there's a kind of a principled argument for why we might want something like Chevron deference as progressives.
As progressives, no matter who is in the White House.
Yeah,
okay.
I think so. And I think the argument goes something like this. We have courts and we have legislatures. And courts and legislatures have particular institutional competencies, right? There are certain things that they're good at. There are certain things that they're not very good at. And when it comes to designing and implementing actual public policy, there are good reasons why we may not want that to be done by generalist judges or by elected legislators who are looking to the next election 2 years or 4 years or 6 years down the line. There are good reasons why we might want a different institutional body that can combine some degree of insulation, some degree of expertise, and some degree of democratic consultation of affected groups in a different kind of process. And I think that's sort of at its most ideal, that's a defense of the administrative process in its own right. And so I don't think I would say that Chevron is inherently anti-regulatory or inherently sort of pro-progressive either. A lot turns on who's running the agency. But I think we have good reasons to want this type of institution to exist in the 21st century when, it's not the 1700s. We can't just have the traditional three branches doing all public policy.
Great. Yeah, please go ahead, Chris. Yeah.
So, and I kind of want to build on that a bit. I mean, so Chevron's a Reagan administration victory, right? This was a way to try to claw back on the administrative state. It was a deregulatory move. Chevron itself was a pro-business move in the Clean Air Act to allow more flexibility under the Clean Air Act. But I do think when we think about, to say it's just politics, I hope one thing you take away from this, and conservatives in their view of the courts are really kind of two big camps, right? There's the Reagan, this is courts, we don't want activists, we want, the less courts do, the better, because they're not politically accountable, and, they just mess things up. Let's leave it to agencies, or let's leave it to the democratic process. And then there's the new, kind of libertarian strand, the Tea Party strand, that I think is really pushing this legislation. If you look at the co-sponsors, you've got Hatch, you've got some traditional, but a lot of it is much more of the libertarian strand that has an inherent distrust of large government and sees the courts as the solution to protecting liberty. And so you have this kind of weird movement where I think, yes, the old school conservatives are jumping on board now because 8 years of Obama has been a lot for conservatives, and because Congress isn't working, perhaps the story goes, Obama's done more, according to conservatives in Congress than maybe other presidents have. But you also got this strand of Tea Partiers that are really saying, we need to trust courts are really the backstop of our liberties and the infringement of those liberties by the administrative state. So I think it is a little bit more complex on the right as well.
Yeah, that's very helpful. Thank you. Yeah, Allison, what thoughts?
I think that that the Dodd-Frank law, which has led to a lot of regulation, is a significant reason for Congress's concern. Dodd-Frank was passed by the Democratic Congress that Obama had for 2 years, and the Congress, the House in particular, since then has been pretty unhappy with the law. The EPA has been much more active over the past 8 years than during the 8 years before it, so we're seeing more regulation. And those are two big sort of flashpoints for the right that I think has brought judicial review of regulation, or brought regulation more into their, made it more of a concern for them. The odd thing, though, is that getting rid of Chevron doesn't get rid of the regulations. The courts are either going to uphold the regulation or send it back for a new one, but there's no question that Dodd-Frank requires a bunch of agencies to issue a bunch of rules. So the law is sort of short-sighted in that way as well, because It's just who's going to decide how to implement the law, whether or not you use Chevron, but it doesn't really go to the fact that we're still going to have these regulations, and it's just sort of shifting policy decisions away from the policymakers.
Yeah, Boris, please go ahead if you have anything.
I'll be extremely brief. I mean, my intuition is that the resistance to Chevron isn't driven so much by the view of the opponents about the courts as it is by their view of the agencies. So it's not that the opponents of Chevron think courts are very good at doing this, but they feel like some recourse from the agencies is necessary.
Yeah, so that's well, there I guess there are two places that I could segue from there. One is, it's an interesting, and I think I can't remember if it's Chris or Allison alluded to this. So it is an interesting thing for Congress to try to sort of say, well, we'll just mandate de novo review, as opposed to, right? Congress does have sort of tools to, if we are worried about the administrative state kind of run wild, there are other, it feels as though Congress, through the statutes that it passes, like, could do a lot on kind of a sort of one-off basis, as opposed to this sort of this Separation of Powers Act. I think it did pass out of committee maybe on Thursday, but I don't imagine. I mean, it does not have any chance of being signed. But it is it's a somewhat serious legislative effort, and so I think it's good that it's part of the conversation. But I guess so that's one question. Is sort of it's not just, right, a question of the executive branch or the courts. Congress itself, I would think, has other kind of remedial avenues potentially if it is worried about excessive power in the agencies. So that's one, and then the other sort of internal. So I'll pose sort of two questions and let folks take whichever of the two they're interested in. But specifically, maybe for Boris, this is sort of a good segue. Sort of how all of this, both the kind of what we're seeing from the court, and then maybe the fact that there's interest in Congress, is impacting the work of or the thinking of OIRA, sort of about kind of regulatory work in general. And maybe you could talk a little bit about what OIRA is and does, maybe before you even get into the question.
Sure. So over the last several presidencies of both parties, the presidents, through executive orders, have created a system of centralized review of regulation that serves a couple of functions. It serves as a coordinating mechanism to ensure that when an agency is promulgating a proposed or a final rule, it does so in a manner that's coordinated with the sister agencies in the executive branch, because what the EPA does may affect the Department of the Interior, may affect the Department of Justice, that might have to defend that regulation in court. Similarly, what the IRS does may affect the Department of Health and Human Services or the Labor Department. So there's Office of Management and Budget has an office called Office of Information and Regulatory Affairs that serves the coordinating function. The other principal objective of the review is to ensure that there are relatively robust and relatively consistent analytics, and this is what people call for short, sort of the cost-benefit analysis. But I think that's sort of a glib and much maligned phrase. But essentially, it is an effort to ensure that there's a consistent analysis of likely consequences of the regulation across the executive branch. I think one question, I think this is what Kate was just alluding to, is does Chevron in any systematic way advantage OIRA, as opposed to the agencies it works with, or vice versa? My own experience is that the answer to that is probably it does not. I guess the way I would think about it is that the law, and the law being with Chevron or without Chevron, establishes some sort of a permissible range of policy options. And then the agencies amongst themselves debate what the better option is and come to some coordinated decision. I suppose it's probably fair to say that were Chevron not in place, the range of possible options would be narrower. And I guess the analytical question is it systematically the case that OIRA's policy preference or an agency's policy preference will then suddenly be outside the range of legally permissible options? And I have not discerned a pattern like that. That said, and we haven't gone into the detail, and we probably don't have time to, but there has been judicial movement towards emphasizing cost-benefit analysis to a greater extent, sometimes in the context of arbitrary and capricious review. And I think were that trend to continue, I think that, that institutionally plays to OIRA's hand.
Oh yeah, please go ahead. Yeah.
So I was hoping when you were going through King v. Burwell that you were going to explain not that the IRS doesn't have expertise, but that interpretation really was the president's, right? I mean, do you think that's the case? I mean, I am sure that rule was conferred with HHS, and that ultimately OIRA and the White House carefully leveraged the entire expertise of the administration to. I mean, how does that story play out? I mean, you've done
that you can say publicly.
What was the likely way that the administration, IRS, it's actually a Treasury reg, how did they come to the conclusion? I mean, it wasn't just the IRS, right?
Let me just start by saying that I don't know if I knew I wouldn't tell you what role the president might have had in it. But the rulemakings, ancillary to the Affordable Care Act, have to proceed in a highly coordinated fashion. Especially between the Department of Health and Human Services and the IRS, and here, even on the public record of the public statements and rulemakings by those agencies, it is completely apparent that they're on the same page. So, to say that IRS doesn't really know anything about health insurance, you should turn to HHS, is a little bit of an unpersuasive answer, because it's completely clear from the record that HHS would have arrived at the same answer. It's just that the tax credit rule had to be promulgated by the IRS, if that helps.
Did you want to get an Allison?
Yeah, I just wanted to mention about the cost-benefit analysis. Mm-hmm. I'm not sure why that term is glib. It seems appropriate to me, but it's just another one of those tools, I think, that if there were no Chevron, or even when there is, courts have a number of different tools for striking down or upholding regulations that the judges like or dislike. Because if we had no deference, but we still have this increasing citation to cost-benefit analysis by more conservative judges and justices, then I think that I, who have very ambivalent feelings about Chevron, might really miss it and wish for it back. But that, like arbitrary and capricious review, are just different ways, really, to do the same thing. The court has to figure out what Congress meant and whether what the agency did make sense. Getting rid of Chevron will just have something else.
Yeah. To make this more concrete, maybe the sort of Michigan was a big cost, right, versus EPA. Does somebody want to sort of talk a little bit about what the court did there and sort of how that figures into the kind of the general conversation about where Chevron is in the Supreme Court right now? I feel like that's a decision nobody's mentioned yet. Do you want to do, Boris? Yeah.
Sure.
Right?
I'll do it very briefly. The decision concerned regulation of certain mercury emissions, and I think the question before the court was whether the EPA, at an appropriate juncture in that regulation, considered cost-benefit analysis. The court held that it did not, mm-hmm. and went back to the agency. And I think my expectation is that some, not too different result is going to come out. And I guess my own view, and this is a little bit, in reaction to what Allison just said, is that not, what I said in my previous remarks is that focus on costs and benefits, I think institutionally tends to, be sort of OIRA's bailiwick, as opposed to some other agencies. Although there are agencies, and EPA is probably most prominent among them, that have developed an extraordinarily robust, economic analysis capability. But I don't. I certainly wouldn't take the position that that cost-benefit analysis, it's certainly not. I don't think today is necessarily an ideologically biased methodology. That is, it is. I think it can be akin to Chevron in that I think it can be used. It can be used by conservatives, but it can as well be used by progressives. And I think, especially in recent years, we've seen a lot of progressives, including some very good work at law schools, using cost-benefit analysis to progressive ends.
I could just add
Please
on about Michigan versus EPA. The reason I think it's sort of striking as a Chevron in the Chevron context is because What the EPA had done was apply a statute that said that the EPA shall decide whether to regulate, looking at some factors as appropriate. It didn't mention cost. And the EPA's position was, we have decided we're going to regulate. It hadn't regulated yet, if I remember correctly, but it said that at the point of issuing the rule, it would consider costs, but in deciding whether a rule made sense as appropriate, costs didn't come in yet. So it was still going to consider costs. And the Supreme Court, even though the statutory language was as appropriate, the court did not defer to the agency. You would have thought that maybe as appropriate was classic deference signal from Congress.
Sabine or Chris, do you want to get in on cost benefit or sort of congressional self-help kind of? I sort of stepped on my own question, but if you want to get on either of those, please go ahead.
Yeah, I mean, just really quick to echo, I mean, I think the worry about arbitrary and capricious review is similar to the discussion we're having about Chevron. Is it a way to enable sort of overly intrusive judicial interference with an otherwise sort of clear agency process? But I mean, I think I agree with Boris that sort of cost-benefit analysis as a general sort of concept is plastic, right? The real question is how it's used by the different actors sort of who are fighting these turf battles, right, between courts and agencies and sort of conservatives and progressives battling over particular political disputes, and it becomes a weapon, right, that one can use. But in and of itself, I think it's sort of can go either way.
Yeah, the congressional self-help is an interesting one. So last week at a George Mason conference, of course, about Chevron, because the chief counsel for Mike Lee was asked the question, like, why would you want to give the courts all this power instead of agencies? And his response, which I think was carefully crafted towards the old school conservatives, was because when the courts mess up, it'll force us to do our job. And I thought that was really interesting because that doesn't seem to make a lot of sense. Because it's really hard to pass new legislation, as they found out. You know, we're down. I mean, it's like the Supreme Court and Congress are competing about how little they can do lately, right? But Congress has a lot of self-help measures they can do to go after agencies. They can have oversight hearings. They can task an inspector general. They can audit. They can, have requests for information. There's a lot of things short of legislation that a committee can do to try to rein in a federal agency. Now, it doesn't always work, and agencies know that they might, but it actually works quite a bit. I've done a lot of work looking at the role of agencies legislating, helping Congress draft statutes. And one of the things they always said is that we always try to get all of our responses out before the oversight hearing, right? We always try to make sure we've cleared our deck so that when our boss goes up on the Hill, she's not going to be pestered about these things that we're doing. And so I think there are a lot of, short of legislating, because legislating's pretty impossible to do in this climate, lots of other things that Congress can do to apply pressure on agencies to act in a particular way. Nothing they can do on courts, short of passing new legislation. So, it's an interesting kind of framing of it that I just don't think works.
Right, and just to piggyback off of that, I think Chris's point about the difficulty of just the sheer temporal and kind of effort difficulty of legislation is really important part of the, as they're trying to think about who should have institutional responsibility, right, for working on this stuff, whether it should be reabsorbed back into Congress in sort of a more classic legalistic sort of separation of powers frame or transferred to courts. This idea of just being able to do stuff, right, in response to changing conditions is really important. And so, I mean, in the last plenary panel, the panelists were talking about DAPA and DACA and immigration and a bunch of sort of in the frame of executive overreach. But I think a better way to understand those developments is as agencies using reservoirs of legal authority responding to rapidly changing conditions in an era where Congress is unable or unwilling to act, right? And that's a very real need.
The one self-help I completely forgot that we need to focus more on is appropriations budgeting, too. That is the one legislative activity that Congress is forced to do pretty regularly, and yet it's also an area where there's a lot of substantive riders and fun stuff that go on that actually has the force of law.
Yeah, I mean, that's exactly the point I was going to make, and I just wanted to make a bridge between what Chris just said and what Sabine said earlier. What makes CFPB, the Consumer Financial Products Bureau, Protection,
yeah.
sorry, different in its structure is that it does not rely on the annual appropriations process. And so, that's sort of the institutional innovation or difference, and it's responding to what Chris just mentioned. And just for those of you who don't live like some of us have in the daily world of appropriations writers, they're essentially provisions that are attached to an omnibus funding bill, and thus, are very hard to resist, because otherwise you'd have to veto the entire bill, that say, none of the funds appropriated herein shall be used or may be used to promulgate or to enforce or to implement this particular rule. And it's a way for Congress to avoid having to promulgate or to having to enact freestanding regulation that the president would then be in a position to veto.
All right, so I want to ask a question about the sort of the future direction of the court, and maybe particularly in light of the vacancy, kind of on these issues. So first, if there was something of a groundswell beginning, where was Justice Scalia in all of it, and sort of what does that represent in terms of his trajectory? So if somebody just wants to give a little bit of background, I think that would be helpful. And then just sort of what the implications could mean. Could some of the skepticism, I don't know, if overruling Chevron is maybe overstated, certainly curtailing certain kinds, some ancillary deference doctrines and that sort of thing. Whether those sorts of things could get 5 votes. And I think a related question is on Boris's the King versus Burwell case we've talked about. I mean, that language was in a majority opinion that was, right, a 6-3 majority that had Justice Kagan, Justice Sotomayor, right, Justice Breyer, Justice Ginsburg. A very strong majority, sort of setting aside the Justice Scalia question, has signed on to that language. So arguably it doesn't, it either does or doesn't follow from the earlier cases that Boris cited. I think people do a little bit disagree about this, but does that standing alone, sort of separate and apart from the other judicial moves we've seen, mean just there is going to be this sort of empowered judiciary, and if it wants to be, when will it want to be, and what kinds of cases will it want to just sort of wrest control over these kinds of discretionary matters from agencies? So I don't know who wants to take if somebody wants to just sort of walk through the Scalia history.
I'll say
Alison, you want to do that?
Justice
Yeah,
Scalia.
thanks.
Well, I don't think Justice Scalia was not particularly skeptical about Chevron. In 2013, he authored the City of Arlington versus FCC, where he gives a very strong defense of Chevron, argues that he's not expanding it when the chief in dissent says that they're going wild with it. They fight with each other. He says that if we had no Chevron, we'd have chaos. He had backed off on deference to the agency's interpretation of their own regulations, our deference, which is called our after an opinion that he authored, but he seemed to have changed his mind. And I think a lot of people thought maybe our was on the chopping block. And it's hard to say now with 8 justices.
He got denied, yeah.
There've been a bunch of petitions, and they've all been denied, and I think nothing controversial, even if only the 5 of us would find that controversial, is going to happen while we have 8. But he was quite strong on deference, on Chevron deference in that opinion, and the dissent had 3, I believe, with Alito and Thomas. So I don't think that Chevron's going anywhere anytime soon. The people signing on to the opinion in Burwell, I don't think that sets any big precedent for Chevron. The precedent it sets in terms of Chevron is that the majority of the court believes that there was no basis for deferring to the IRS in that particular case. So I think you can cabin that pretty discreetly. And I think it's now, what do we have, 8? So it's 5-3 for Chevron now. And even in his dissent in City of Arlington, the chief was not saying that he disagreed with Chevron in cases where it looked like the agency was acting within its delegated authority to fill a gap within the area of its expertise, the sort of traditional meat and potatoes Chevron case. So I don't think the chief would actually want to do what the Separation of Powers Restoration Act thinks that it is doing, though he certainly would disagree with it in some cases. And in those cases, he's managed to decide issues without using it. Interestingly, in Burwell, he didn't defer to the IRS. but he wound up agreeing with them, so.
Yeah, Chris, go ahead, please.
So at this George Mason conference last week, which was just a gold mine for fun stuff, Boyd and Gray spoke for a while, who was a good friend of Justice Scalia, and this is the People magazine version of the panel. He suggested that in their private conversations that Justice Scalia in this last year had a recent turn of heart.
Doubts about
on
Chevron? Really?
yeah.
Interesting. Huh.
And that might have been the next big project for him.
Wow.
But I do want to get on this idea.
I think we just made news. That's awesome.
Well, yeah, it's like tweeting out. Yeah, go check out his transcript because he was.
Wow, that's great.
But I do think Scalia's passing though does open the door for the chief to flip on City of Arlington, and I think that's a huge difference. So the main debate between the chief and Scalia in City of Arlington was, if the agency has rulemaking authority and it uses it, Scalia says in the majority opinion, you get Chevron deference and we're done. And the chief, with Kennedy and Alito in the dissent, said, no. We've got to look at the specific statutory ambiguity and ask ourselves, did Congress intend to delegate lawmaking or authority to the agency? Not like as a whole, just as long as they get rulemaking authority and they use it, but no, we're going to look at the specific provisions. And that had a concurrence from Justice Breyer, and if anyone follows Justice Breyer, he loves this stuff. This is his Meade Barnhart. Let's really figure out if Congress intended. So you've got 4 votes now already for a more provision-by-provision approach. And then Justice Thomas says he has serious constitutional concerns about Chevron. That's your 5th vote if you wanted to do a narrowing of Chevron. And I think the chief's approach, as if you read Justice Scalia's opinion in City of Arlington, he's like, this would be a disaster for Chevron if we're trying to have any continuity in the law. If we adopt the chief's approach of determine whether Congress intended, like, so all the circuit courts are going to be like, is this the type of ambiguity that like we think that Congress wanted the agency to answer? And I think at that point it would allow for a lot more mischief at the lower court level on Chevron deference. And I think it's quite possible that we have that. I don't know. King v. Burwell, the major questions doctrine, I'm a little bit more skeptical, although I think that is a variant of the chief's section by section. But I think it is quite, we've got 5 votes, I think, for a very context-specific type of Chevron deference.
But right now, they've been sort of reserving for these big cases like Brown and Williamson or Burwell, but the chief wants to do it in the little cases.
Right. Yeah, and just building off of that and channeling Boris's source citing hat, one of the things that Roberts is actually really good at and subtle about is source citing himself a few years later to build on the principle that he himself created. Right, so trace back the Shelby County voting rights decision, and that's exactly how that comes about. And so I could imagine, sort of similar to what Chris and Allison are saying, I could easily imagine an outcome where Roberts gets an opportunity, maybe 3-4 years down the line, to revisit this 6-3 language in a way that maybe some of the other 6 maybe weren't intending, but they like the overall result, and so they're on board with King v. Burwell. But so it could be exploited down the line.
Yeah, in the Northwest Austin, that first Voting Rights Act case, he also had most of those same people sign on to some language about the changed conditions, and then it had a very different payout a few years later. No, it's a nice point. Did you want to jump in, Boris?
I'll just say one brief thing. So one thing that source sites are not really good at is finding contrary authority, right? And so if you read that paragraph, that I talked about at length at the beginning in King v. Burwell, and so it's, basically, this is too important. So you would think, if you just read that paragraph and you read the cites in that paragraph, that there isn't some opinion out there that says, okay, there are, Chevron doesn't distinguish between big important decisions and humdrum run-of-the-mill decisions. Chevron applies to both of those. So those are air quotes I just did. Those are actually actual quotes, and they're quotes from City of Arlington, which was decided all of 2 to 3 years earlier. But that case is not alluded to, explained, distinguished, or even cited in the King v. Burwell majority. And I think we can have sort of a complicated and an interesting conversation about which way this kind of activity tends, from an ideological perspective. But I just have an objection to it because it's a mess. And I have, and I don't think it should be.
Yeah, so if you have one takeaway from this panel, right, the doctrine is an absolute mess. I think we actually are at the point when we could start taking questions from the audience if you guys have any, so feel free to just line up at the microphone. All right, so we'll start one at a time, and then if we start to get short on time, maybe we'll stack the questions. But please, please go ahead.
I have to preface this. I don't like public speaking very much, so bear with me.
It's okay. You sound great.
My name is Portia Brown. I work for a civil rights firm in Texas, really liberal state. I'm a baby attorney, so please, if the questions, if I should already know, my bad. So this is not a policy question. It's how should public interest litigators move forward after an agency has been required to reevaluate its agency definition?
Required by a court to, is that, okay? All right,
Yeah,
sorry,
like
finish
it's
your
been
question.
remanded and they're
Yeah.
like, make a new definition.
Uh-huh.
I may or may not be asking because I have a case or something like that. But so do we need to wait until a new definition of the agency's term is appropriated before filing litigation, or is it more productive to file a suit once a new definition is decided?
This has got to be an Allison question, right?
So
I didn't understand the last part of the question.
is it better to wait until the agency determines a new definition, or is it better to just say they won the Chevron, so let's file a suit right now? Chevron has required the agency to make a new definition.
So if the court has vacated the rule and sent
Right.
it back,
Yes, ma'am.
then you're going to need to wait till there's a new final agency action. But you can, in the meantime, try to participate in the rulemaking during the notice and comment process, which has to start again when they propose a new rule. Sounds like you're expecting to have to sue again.
Yeah. Is that
but-
considered like lobbying though, or
Submitting comment? No, that's not
Yeah.
lobbying.
just curious because
Right,
I'm a new nonprofit attorney. I just really
yeah,
don't want to do
a C3
lobbying.
can submit comments to the agency,
Okay, cool. Thank you.
and you should.
Good luck. Ganesh, hey.
Hi, I'm Ganesh C. Drummond. I teach at Vanderbilt Law School, and I want to put together a couple of comments from Chris and Sabeel, and then ask you to think a little bit forward-looking and in kind of a big think way. So it seems like there's two different models for how we can imagine a Chevron-related administrative state. The one approach of the anti-Chevron people is we should get rid of Chevron, courts should make decisions, and the key difference between court making decisions and agencies getting to interpret statutes is that when the court interprets the statute, the only way you can change the interpretation is by going to Congress. This is a feature, not a bug, if you don't want Congress to do things, because it's very hard to get things done in Congress. So as a result, what you get is laws that are not consistent with changed circumstances. And so in a modern, constantly changing society, what you end up with is old laws, and it's very hard to adapt modern problems to them because courts will interpret narrowly. Congress is the only one who can fix it. You can't get anything done, right? So that's one approach, makes sense in some ways, and I think is systematically, in some ways, anti-regulatory in a world where Congress doesn't want to do things. The other approach that I think Sabeel sort of alluded to is part of the goal of having these agencies is they mix expertise, accountability, stakeholders, and some degree of insulation, and therefore are able to adapt to changed circumstances in a way that we shouldn't expect Congress to do for all of Congress's inherent problems, just a lot of things going on in the world. That's why we have these specialized agencies. So if we're thinking about these two models, the conversation today has been somewhat technical about the courts, but what Chris started us with was a statute from House Republicans, I think it was, Senate Republicans, House Republicans, trying to really push forward the first model and make it into law. If at least Sabeel seems to believe, and maybe the rest of you do as well, in the second model, what are the affirmative things you would advise people in Congress or the next head of OIRA in a new administration or whatever to try to do to establish a sounder footing for the second model? Because that seems, would you say there should be legislation mandating Chevron, legislation going farther than that? What would your advice be? Thanks.
So I can take a stab at that. Starting with Ganesh's question, I mean, I think there are a couple of things that could be done. One is you could imagine, I think part of what's interesting about the CFPB model is that, if you're if Congress is presented with the opportunity to create or reform an existing agency, there's a lot of potential to design the agency through statute in ways that can make it more responsive and effective and adaptable. The same summer that Dodd-Frank was being debated, that was the summer of the oil spill in the Gulf, and Congress was considering legislation to totally overhaul the Minerals Management Service to make it more sort of resistant to oil industry influence and more responsive to sort of changes in technology. And there are a lot of really interesting statutory proposals of how the agency might be structured to do that. I also could imagine executive order or sort of the presidential oversight of the administrative process to sort of start pay attention to some of these more kind of complexity adaptation questions. And then one thing I'll just say to Portia's question, I don't know where she went, but Allison's point about participating in the notice and comment process I think is really important. I mean, for those of you who are practitioners or law students, either way, it's really important to remember that agencies are a site, a forum in which the usual things we think about, lobbying, advocacy, social movement, civic engagement, all of that operates just as much in the administrative process as it does in the ordinary legislative policy process. And we often tend to not think of agencies in that way, but I think as progressives and practitioners, it's important to sort of keep that front and center in our minds as issues come up.
That's great. Any other? No. You do,
Let's
Chris.
say
You
real
want to go ahead,
quick,
please?
so one of the odd things about King v. Burwell and about the legislation is nothing about Skidmore deference, right? I mean, so I think like the middle ground kind of between like the two polar worlds that Ganesh has illustrated, you could imagine a different world where the agency has to use its expertise and demonstrate that it actually knows what it's doing, and that so you could imagine a
And then
third
wait,
world.
so Skidmore, just for folks who don't, yeah. So what is that world?
Skidmore deference is the deference that usually used to always apply when Chevron did not, but King v. Burwell kind of didn't even mention it. But there, the idea is that they don't have the space to play, so an agency doesn't get the whole ambiguity to play in what and for reasonableness. It's that they have to come forward based on their expertise, based on how long-standing the interpretation is, a number of different factors. It's more of a standard than a rule. And justify that, hey, we're the experts, not you, court, and based on our expertise, this is the best way, or this is a really good way to advance the regulatory and statutory scheme. And so I think that might be a different world where the agency might be forced to kind of demonstrate that it's done its work, and it might be a middle ground between the two.
Interesting. Yeah. Okay, Boris, if you want to jump in, go ahead.
I'll just say a couple of quick things in terms of what improvements there might be. My own view is that we've now for several administrations of both parties have focused on going forward projections of what the outcomes of regulation should be. I think there's probably some room to try to think about more mechanisms that I guess to me sound a little bit more like accountability, and here's what I mean by that. I think we don't have a lot of regulations that are promulgated with some anticipation of costs and benefits, but with a concrete plan at some point in the future for testing whether those costs or benefits have come to pass. Now, I'm not suggesting that as an anti-regulatory move, because just as an agency might have declined to regulate because of costs and benefits, there may be a concrete plan in place for revisiting in the future whether that decision was appropriate and whether regulation might be appropriate at a future point. I think that would, I think people sort of in the real world tend to be accountable for whether they achieve their projections, and I think there will be more buy-in into agency work if agencies try, do the same. And I think, just truth be told, I do spend, some of my time representing, private entities that are being regulated, and I have to say I think there is some room for improvement in explaining why agencies do what they do, because sometimes I'm in a position to have to explain to a client how this explanation in the preamble makes any sense and leads to the conclusion in the Code of Federal Regulations. And let me tell you, it's not always easy.
Great. Go ahead, Allison. Yeah, please.
So I think your idea is interesting, except that agencies are already so chronically behind in issuing the regulations that they need to issue. They miss congressional deadlines on a regular basis. There's all sorts of safety regulations that haven't happened. There's regulations that are proposed and then they just sit out there for years. OSHA hasn't updated various standards for decades. So maybe this takes us back to the appropriations process. But to add that as it's not a bad idea in theory, but in practice, we just never get anywhere. I just wanted to say one word about Skidmore deference, which is the shorthand for Skidmore is that the court will defer to the extent the agency has the power, or agency's argument has the power to persuade. And I always hope that the court will also defer to me to the extent I have the power to persuade. I just don't really, I've never quite gotten what it is or a case where it really makes a difference. And the current version of that statute, the de novo review, I don't know if that allows for Skidmore or not. I'm not really sure.
Don't want it to, I don't think. But
yeah, and then also we still wind up, whatever we want to do with Chevron, whatever the chief wants to do, and if maybe one day he has 5 justices to do it with him, we're still going to have cases like Chevron where, I just got this out, where Scalia said, Stevens said, we're not persuaded that parsing of general terms in the statute will reveal an actual intent of Congress. That is, the court doesn't know what to do. So do we want the court to decide how the EPA should have regulated in this case or not? I mean, maybe the outcome would have been better after all the NRDC was on the losing side. But I think that's sort of an odd task to give to the court.
Okay, so let's take another question. Please go ahead, and if you don't mind introducing yourself first. Thanks.
I'm John Heineman. I work at Promontory Financial Group. So y'all have been discussing cases that the Supreme Court has settled. My question is a little bit more out in the weeds. So last year, under Dodd-Frank, which y'all have been talking about, the FSOC started designating insurance companies as systemically important financial institutions as well. A couple months ago, a judge struck down the MetLife ruling. And so, this isn't an asterisk. That's what FSOC is supposed to do, and it's pretty hard to say that MetLife isn't a systemically important financial institution. So the case is sealed right now. It's still going to go up on appeal, but I'd be interested to hear you guys discuss.
She unsealed her opinion.
What's that?
She unsealed her opinion.
Oh, she unsealed her opinion. So it's, if I understand correctly, it's about cost-benefit analysis, and I'd just be interested to hear y'all discuss a little bit about what this has to do with the future of Chevron deference, if it has a potential to harm Chevron deference, or clarify where courts stand on it, and what the blowback might be on that.
Let's try to limit to 2 minutes so we get to the last 2 questions. Who feels like, Allison, you're following it closely, yeah.
I think that's a case that shows that sometimes the court will just do what it wants to do. Totally could have deferred, or even without deferring. I thought the government's briefs were incredibly persuasive. But had she deferred, they absolutely would have won. The court decided to apply Michigan versus EPA to say that the government here also needed to consider cost in determining, it's sort of confusing to me, the cost to the agency and the cost to MetLife of the determination that it would be too big to fail, when the determination was based on the ramifications and the consequences of it failing. Obviously, if it failed, there would have been a lot of cost. But she carefully uses language from Michigan versus EPA. When I first read the unsealed opinion, I actually thought it made total sense, and I read the government's brief and thought the opinion was totally off base. So that's my view.
Sibylle, you want to jump in?
Quickly,
Yeah.
I think the MetLife decision sort of points to something that Allison and others alluded to, that the danger of the worries about the arbitrary and capricious review doctrine, not so much Chevron doctrine, and it's we're seeing this pattern a lot post Dodd-Frank as almost like a new formalism where the D.C. Circuit and now this MetLife case is using arbitrary and capricious review and the idea of cost-benefit analysis to roll back what otherwise seems like clear delegations or even statutory commands, depending on how you read the statute, to the agencies. And in financial regulation, it's especially hard because it's almost definitional. The cost-benefit is really hard to do in something like systemic risk because it's almost, yeah, it's baked in, right? And so there's some great research about how it's kind of an incoherent notion.
Okay. All right, great, thanks. Yeah, next question.
Hi, thanks. My name's Peg Pearl. I'm from Colorado now, but I used to be here in D.C. and was an attorney within the Federal Election Commission, and had the dubious honor of doing a cycle of writing regulations, defending them in court under Chevron, getting them kicked back, and rewriting them to try to comply with Chevron Step 1 or Step 2 losses, or both, or Step 0. It was different at every time. But my question really is about the panel, if you have any thoughts or have been looking into basically the way that the Chevron deference, especially under Step 2, seems to be problematic sometimes when applied to commissions as opposed to other types of agencies. Because Step 2, when you're looking at the reason for why the agency adopted the interpretation it did or why it's going down that road in the regulation, when you're at a place like a Federal Election Commission or the SEC or the FCC, where really it's almost a little more legislative in the sense of the sausage making of how you get a majority vote on the commission for this rule, and then you go through the same process of getting the majority vote on the commission for the explanation and justification that then is used to explain the rule and justify it. And sometimes the only way you get to those votes is by not saying things or saying things in a certain way. It just seems really interesting to me that the sort of the standard applied in Chevron for a single agency head seems to be applied equally to those commissions. And it seems like sort of trying to make a not apples to apples comparison. So if any of you could just discuss on kind of how that applies in a commission context versus other types of agencies.
And I'm getting a 1 minute sign, so maybe I'll take the last. Oh, okay. We have. All right. So actually, we will take the. So commissions or independent agencies, right? Multi-member, bipartisan headed bodies. If anybody wants to talk about sort of how this cashes out differently as between.
I've still got to run my data on that. I haven't divided up. And it's funny because when you mentioned this, I was going to run it independent versus executive, in this 1500. But now I think I want to also run it by commission because I think that's even more fascinating. I'd be curious to see. There were 51 cases out of 1500 where the agency rule was struck down at Step 2, and a lot of that was. Again, I'm still kind of working through that. A lot of that was based on more of a purposivist type argument. So maybe the text is ambiguous, but that surely isn't what Congress intended. And I think commissions, especially when you have dissents, make it really messy, right? Because they just kind of outline exactly the sausage is made in public. And I think it does change the way it gives ammunition to courts from a Chevron Step 2 perspective, I would think. But I need to dig deeper into my data.
Any other thoughts? No. Yeah, go ahead, please.
I guess the only thing I would just say is, well, it's not, I think, unrelated to the question about why 4 justices who were in the majority of the city of Arlington signed King v. Burwell, right? It's like there is a difficult juxtaposition between the logic we expect from our courts and we expect from our agencies and the politics of small groups that has to occur when you're trying to get a majority vote. And I think the same question arises. There's some movement that comes up from time to time, especially with respect to financial regulation, about making regulations of the independent agencies, most of which are multi-member bodies, subject to OIRA review. And I think that raises, putting aside the merits, pro and con of that proposal, it does raise the same, institutional question. Well, how would that work, given the dissenting members?
Okay, so last question, please. Go ahead.
I'll be really quick.
Thank you.
And I don't even require an answer. This is really more in the nature of.
Sorry, do you mind identifying yourself? Sorry.
I'm sorry. I'm Simon Lazarus. I'm at the Constitutional Accountability
Sorry.
Center.
Nice to see you.
And I just wanted to amplify or correct the record on one small but important point. One of the panelists referred to the Consumer Financial Protection Bureau as a kind of an outlier in that it is not dependent upon annual appropriations from Congress, but it has a guaranteed funding from the Fed and the Fed's funds. And this is a part of the conservative attack on the CFPB, and it's really quite misleading because in the world of financial regulation, most of the agencies do not depend on annual appropriations. They are independent and they are funded from revenues that come from the regulated community. And in the case of one, for example, the Office of the Comptroller of the Currency, which regulates national banks, it puts them in a competitive position in that they need to keep, the banks can decide not to be regulated by OCC, so it gives OCC a big incentive to do things that are favored by the banks. So the CFPB is the only agency that really has protecting financial consumers as its mission. The other agencies, as the panelist on the end of the table very appropriately emphasized, agencies become players in the game of competitive advocacy, and that's certainly the case in financial regulation. So Congress gave the CFPB this source of automatic funding really as a way to make it, put it on a par with what are in fact competing financial regulatory agencies, which generally have tended to shortchange consumer interests. So I just wanted to
Okay,
point
thank
that
you
out.
for that. And we're standing between you and lunch, and that is going to begin immediately after the panel in the presidential ballroom. Thank you so much, everyone, for your attention.